right, we're on record today for a putative father hearing and a pretrial in the matter of the Ledbetter case. May I have the names of our participants, please?
Carson Howard, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department. Ms. Pelham.
Sophie Pelham with CPS.
Michael McFarland representing father. Mr. Everett, please introduce yourself.
Daniel Everett's father.
Okay. All right. Attorneys, could you all confirm that you received a copy of the DNA testing in this case?
Yes, Your Honor.
Yes, Your Honor.
Your Honor, I'm not sure if I received the copy of the DNA testing, but I did receive a copy of the order in the paternity matter establishing Mr. Everett as the biological father.
Very good. There should have been a copy of that DNA testing attached, but
Attached.
if you
I'll double
need it,
check.
make sure you get that as well.
Thank you.
So essentially, the first order of business is determining whether or not Mr. Ledbetter will be subject to an amended petition, or how the department intends to proceed. Ms. Thomas, if you know.
Yes, Your Honor, thank you. We did begin to amend that petition. I have not filed it yet, given that I was not sure procedurally if his paternity was established in this case as well. And so I did not want to file a petition, put the cart before the horse, so to speak. So it is our intention to file a petition naming him as a respondent, given some of the concerns that we had at the onset of this case when it was brought to CPS attention. But otherwise, that should be coming within the next day or two.
Okay, so for purposes of today's hearing, what does the department hope to accomplish?
At this time, we would just ask the court to set a final pretrial, giving us enough time for Mr. Everett and Mr. McFarland to communicate and see if we have any other issues that we need to iron out at another pretrial, and then also setting a trial date for this case.
Mr. McFarland?
Well, if the only amendment is going to be that he is the biological father, we would stipulate to that through the DNA testing, and there are allegations against him here that we're prepared to admit for the court to take jurisdiction, Your Honor. Reunification, we don't wish to have any additional delays on this. So the request sought in this initial petition was jurisdiction. If that's still the case, we are prepared to, unless there's going to be new allegations made. So that's our position. And there is Native American heritage, at least 3 tribes, that needs to be explored on my client's behalf. You want to bring that to the court's attention.
I do have what appears to be some Native American heritage search documents that were provided to the clerk's office on February 13th, 2025. Ms. Thomas, did you wish to address that briefly?
Yes, Your Honor. Ms. Pelham filed those with the clerk. There are several. It's one of those cases where we have several tribes that were notified. I believe it would be helpful if we had a chart, and so we could kind of go through that. But I believe that Ms. Pelham can answer any questions about what was sent out to who and when, and if anything else has been received. I will note that I also received an email from one of the tribes on Friday that denied any eligibility for membership. And I will pass it along to the court as well.
All right, Mr. McFarland, did you receive these search documents?
I do, but what I received are not the green slips, as we would call them, signature sheets by the tribe. I don't see that attached, Your Honor.
Right, I have the inquiry itself, it looks like, as well as copies indicating that a number of tribes were served, and that it appears they're still waiting to receive the green cards and or potentially letters in response.
What I'll be looking at, just to let the court know, as I did last week, I'll be looking to see that the person who signed is actually the agent listed under ICWA who is appointed to sign for these letters.
Right, would you provide Ms. Pelham, unless you have a copy already of the list of designated recipients for the tribes?
I provided that to the attorney for the agency, Your Honor.
I don't have it personally,
Okay.
but Ms. Thomas has told me she can give it to me.
Okay, all right, well, thank you, Ms. Thomas. All right, so we'll look for some updates on that point then at a later time. Mr. Howitt, what are your thoughts on the request to stipulate to making Mr. McFarland's client a respondent and entering a plea?
I'd be agreeable to that, Your Honor.
And any thoughts on the Native American heritage issue?
It sounds like the agency and attorney for the father, putative father, are working that out. I did not receive any copies of the Native American heritage inquiry. I don't know if you could just email that to me after this, but that'd be fine as well.
Okay, yeah, I don't think there was a proof of service on this actually.
Okay.
So I couldn't, yeah.
That's
Okay, well, I think we would need an official amendment, and we can look for that from you, Ms. Thomas, in the next few days as far as Mr. Everett's is concerned, but I'm not sure that would hold up your client's opportunity to engage in services, Mr. McFarland, if he so chooses. Ms. Thomas, what is the department's position on that? If you know?
Your Honor, I know that this is being handled through Fostering Solutions. Ms. Madrid is logged in right now. I don't think that there would be any delay in them working together to establish a case service plan and get some services started at all. And so I can ask her to make sure she does that.
Would you like us to pursue that inquiry, Mr. McFarland?
That'd be fine, Your Honor.
Stephanie, did you swear in Ms. Madrid for us, please? She's joining us by Zoom, but she doesn't have her camera on.
Thank you, Your Honor. Ms. Madrid, can you raise your right hand? Please let me know when it's raised.
Yes, it's raised.
Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Ms. Madrid, as it relates to Mr. Everett's and getting any services started, have you been able to talk with him yet?
We did have a brief FTM prior to one of his parenting time visits, where I did make sure that he knew everything was voluntary, but we did briefly go over what will be a proposed case service plan. So he is understanding of what we will be asking from him. And I do believe he has already started parenting classes through Care Pregnancy of Lenawee.
Wonderful. And will the fact that we do not have official jurisdiction over him at this point in time prevent any referrals from being made or services getting started?
Nope. I was able to give him or point him in the right direction of where we're going to be getting started, letting him know he'll have to do a psychological, and discussed all of bullet points on his case service plan that is proposed. And he's already gotten started on some of those fatherhood parenting classes.
Wonderful. Thank you. I have no further questions of Ms. Madrid, Your Honor.
Mr. McFarland?
Nope, I'm satisfied, Your Honor.
Very well. Any questions, Mr. Howitt?
No, Your Honor.
All right, I have, if we're looking at dates, Monday, March 10th at 10:30.
I'm officially withdrawing my objection to not proceeding today, Your Honor. We have no problem with amending as long as I've heard this testimony.
Very good. All right, so I'd like you to look at Monday, March 10th at 10:30. Or just, we'll just continue today's pretrial until then. To allow the department to make those amendments and to continue to provide those services for Mr. Everett in the meantime.
At what time, Your Honor?
10:30? Okay, as far as continued removal goes, Ms. Thomas, presentation on that point?
Your Honor, if I may ask Mr. McFarland if he's objecting to the continued removal. This is, Your Honor, just admittedly, this is procedurally where, in my opinion, it becomes a little gray because we didn't have a legal parent to remove from. We are still asking the court to maintain the child in foster care with the relative fictive kin placement. So I'm not sure how the court would like me to address that, especially that Mr. Everett's today, in this case, just became legal father.
We are okay keeping the fictive kin placement and the visitation.
All right, very well. Your thoughts on that, Mr. Howard?
Yeah, I think it's definitely in the child's best interest to remain with foster care, victim placement.
Well, thank you. Did you wish to articulate about a visit that you may have had with the child today, Mr. Howard?
Yes, Your Honor. So I met with the child in his home on February 5th, 2025. The child was very happy and playful. He exhibited many developmental milestones such as pausing when hearing no and walking backwards. And I watched him roll around on a toy car for most of my visit, which was very impressive. And whenever he would fall, he would look for comfort from his caregiver and placement, which I think showed a bond. The child, he has a big playroom in his house with lots of toys, and he's eventually gonna have his own bedroom. The house is appropriate. When it warms up, he'll have a lot of room to run outside. And the child has only lived in this home too, so it's really all he knows. Other than that brief period with Mr. Everett's. The placement cares deeply about the child and I had no concerns with her, and I definitely think it's in his best interest to remain there. I was unable to make a determination of what he wants to do with his age.
Thank you. All right, anything else for the record today, Ms. Thomas?
No, Your Honor.
Mr. McFarland, anything else for the record today?
No, thank you.
Mr. Howard?
No, Your Honor.
Very well, thank you. The court finds all interested parties will give a notice for purposes of today's pretrial. The order will reflect the determination and finding that Mr. Daniel Everett is the legal and biological child, the father of this child. We'll look forward to the agency continuing to provide referrals for Mr. Everett and visitation so that he can work on his skill sets as well as his bond with his child. And unless there's any questions, that's all for today. We'll see you on the 10th of March at 10:30.
We're off the record. Can we verify the court has my client's information?